He's with Commissioner.
What is a true grade fraud liberal?
I told him already, he doesn't have his laptop, Larry.
Rails is just college meeting.
Yeah.
Yeah, he said it's okay.
Okay.
He's gonna start singing tonight on Wednesday nights too.
Well, St. John's is gonna say.
I think that's probably what that's what he said. He said I thought I it, but
How many mics should we have?
that's
One more?
That's plenty.
Right.
That's plenty.
thank you.
Right, it's just as an
A lot this room.
It's hot and I feel like it's
So they say nice things. Oh, yeah. Are they moving on it? Are they moving in your direction?
I see the day I find to but that's kind of the process of right now, so we have a nice break down.
Yeah.
I put it on twice. At the top and on the bottom.
So, you might be saying, I know how we have,
Yeah.
so it's kind of explaining the arts.
Right, so it.
And engineering.
So one of my favorite quotes, are you familiar with Edward Wilson? E.O. Wilson. He wrote a.
They're on there.
This guy's great. He writes very philosophical stuff for the last few years. He's at Harvard.
It's pretty cool.
Well, that's all right. What is it?
Right, we think it's about. But it's in the public domain, so you guys wanted to do that too. And I'll let you start.
What I did ask her back to you.
Public investigator being retained by the government. They're not lobbyists, I'm just like, I'm sorry.
There's a warning, there's a warning.
Ready on the right? You're supposed to say the right is ready.
That's fine.
Yes, he says. Well, it must be okay then.
It's okay, right.
Also say if you want to, mic.
I didn't do it.
Oh,
I was like that. It was set up to make me break it. Okay. Okay.
It's probably good. Because she doesn't want it to wake up.
Okay. So is it showing on their screen?
Yes,
Alright.
they tested it.
It's not showing yet when you do your presentation. Sounds great.
Actually, why don't, if you're ready, you want to give Ellen the cue, you plug it in, he hasn't plugged it in yet. Are you ready? You just show the. She's ready. Well, oh, wait, we're gonna have to do public comment first. Once he's done his public comment, then he'll plug it right in. Should I start it? Guys? Yeah, but I mean, like, it's still. You're gonna be in the queue.
Yeah, I would drop it down once after Ben called meeting.
Absolutely. I've got 1, 2. Oh, I wrote on this one. I've got one left. We haven't yet. Yeah.
Good morning, this is Brian Hatch.
Good morning, Commissioner Hatch. We're about to get started.
Okay, great, thank you.
All right. Good morning, everybody, and thank you for being here today for our enforcement focused meeting. Ms. Linker, can you please call the roll?
Commissioner Cardenas,
Good morning, I'm here.
Commissioner Hatch,
Here?
Commissioner Hayward,
Here.
Chair Matich.
Here. So we're going to begin first with public comment on items not on the agenda. Do we have any public comment in person on items not on the agenda or any digital public comment? All right, seeing none, we will turn it over to Chief of Enforcement West for her presentation. Thank you for being here this morning.
Good morning. The screen should turn on here pretty soon. Maybe. Do you want me to restart? Okay, now you can see it. So thanks for coming. This is the Enforcement Division Retrospective Prospective. And the reason it has such a mouthful of a name is that it's a policy meeting, but it's about what happened in 2019 and what's happening in 2020. Everything's working. And thank you for your patience with technology. It doesn't generally like me. So we're just going to start off with just a couple slides on overview for people that aren't that familiar on how enforcement gets a case. So the sources of the cases are generally complaints, sworn, non-sworn, and anonymous, the FPPC SCI unit, and other filing officer referrals, audits, audit referrals, media reports, staff-initiated investigations, tips, and referrals from law enforcement agencies. And so it basically is the universe. It's good now. We have an online complaint system, which has been very helpful for generating the information into our database. So that has saved us some time to where we used to have to physically input each complaint received, and that was very time consuming. And there were a couple of glitches in the complaint form that we then have gotten the vendor to fix, and we'll be launching the new complaint form hopefully before the March election. So that should take care of it. It was a very strange situation. Sometimes there were certain computers that the complaint form just did not like to receive complaints from. And we didn't even get to pick which computers those were. So it was very discouraging. But so we've gotten those kinks worked out, and we'll launch the newer version, and that will help us also track referrals in a more detailed way, which we can't currently do. So for intake, basically what happens is all complaints and referrals go through our intake process. So we have 4 political reform consultants that will look at complaints and referrals to determine whether or not to make a recommendation to open a case. And in determining this, the intake staff review the complaint and the referral, any additional information provided by the complainant or the respondent, the available information and any materials submitted by the subject of the complaint. If the intake staff determine that there's sufficient evidence to present to suggest a violation may have occurred, then they make a recommendation to me to open a case. And then I have to take into consideration resources and other issues and likelihood of success in order to see if we should open a case, because as you know, resources are finite, and so we have to make some tough decisions sometimes. So for investigations, the attorneys and the investigators work together to gather evidence to prove or disprove violations occurred, and auditors and other staff sometimes assist with these investigations. And we have subpoena power, as you can see in the middle of the slide, but we have to seek voluntary compliance, but unless it's for a bank subpoena. There's certain vendors that require subpoenas as a matter of course. They will not, their policies and laws won't permit them to voluntarily produce records. And then also if there's some sort of threat of destruction, confidential cases, you generally see this where there's an allegation of laundering and we're trying to get communications before they can be destroyed. And then the executive director is the one that signs off on the administrative subpoenas. And he has to check if the records are material to the matter, and if he reasonably believes the person that we're going to subpoena has those records. So, and that is in regulation. And then for audits, the PRA requires the FPPC and FTB to perform certain audits, the candidates committees and lobbying entities. The FPPC has the authority to perform discretionary audits as well. And the FPPC performs audits under contract. The audits FPPC is required to do are for state controller, the PERS, and the State Board of Equalization. Auditors can also assist with complicated campaign investigations when workload permits. As you saw yesterday, the Kurt Hagman audit was done internally under the San Bernardino contract, and the Canciamilla case was also an auditor assigned. So then the types of resolutions. So this colorful chart shows you that all the different ways an administrative case can go, all the way down to a civil action, which is under the authority of the commission, but with permission of the civil prosecutor. So no action closure letters are generally, you're saying there's insufficient evidence to prosecute. And we also have 3 standard phrases that we use for no action letters that were approved by the commission last year, and those have been incorporated to where if we've actually disproven the violation, we say that in the letter. Advisory letters where there's insufficient evidence to prosecute, but it appears that they need some information or education on the issue. So we say, you either didn't cross the line out of luck or knowledge, but we want to remind you where the line is. Warning letters are if a violation is found, but the seriousness of offense is low. The commission has processed those regulations that help us determine when a warning letter is appropriate. And then stipulations where we have the streamline program and also mainline stipulations. Default judgments are for the people that don't want to participate in the process. We've done 7 of those this year. And then administrative decisions are either the commission has held an administrative hearing with the help of an administrative law judge or administrative law judge has, and it comes back before the commission before being final. So those are their resolutions. And then just to go into the settlements a little bit more.
Excuse me.
Sure.
I apologize. Mr. Chair, did you mention whether and when questions from commissioners would be entertained?
Feel free to sort of an interactive discussion among the commissioners and Chief Enforcement West. We'll take public comment at the conclusion of Chief Enforcement West's presentation. So if you'd like to ask a question, feel free.
I do have a question, and it relates back a little bit to the actual determination of whether or not there's a sufficiency of evidence in a particular complaint that has been received to carry it further down the process. You have 4 intake people?
We do.
And they kick it up directly to you?
They do.
And you make the determination of whether or not there is a sufficiency of evidence?
I do.
And then you assign it to, as whatever your process is for assignments, based on quantitatively and qualitatively who's doing what?
Correct.
To what extent is the calculus that drives the sufficiency of evidence determination institutionalized so that it is it's independent and rational and not necessarily embedded in and imbued in any particular individual determinator? Mm-hmm. In other words, if after you go, I don't know, after you leave, someone else is going to make the determination. And how will she know how to do this?
Well, what we have is we're currently working on an intake manual, which helps give the intake staff sufficient guidance of what criteria and factors they should be looking at for different types of complaints and referrals. And that helps them be cohesive. We constantly communicate between the intake staff and myself to make sure if I see anything that's being handled differently by one person or another, we constantly communicate and we make sure that we're putting it down in writing or make sure everybody has an understanding. And then also in the manual, it talks about what is sufficiency of evidence. So those are the safeguards for the intake, and I would say the intake is almost more critical than my position in reviewing it, because they're the ones that are reading every piece of evidence that's submitted and putting it into a memo form for me to look at. Obviously, I can then look at the evidence if I have any questions, which I do, but it's about making sure that everybody's consistently analyzing them the same way. And I think that's what the safeguard is. Okay, so with streamline and mainline stipulations, you guys can obviously read the slide, but I would say that the main thing I would want to point out is that for the FPPC, the commission has always felt that an admission of liability in an administrative settlement is important. And so it's something that we require, that there is some sort of admission as to the taking the personal responsibility for what happened. And that has traditionally always been the same way. Most commissions are the same way. There are some exceptions There's other local commissions that are either considering or have changed to more of a NOLO, kind of no admission. And, the benefit of that is you're going to get faster settlements because you're not getting any admissions of guilt. And so disclosure to fix the issues, the public disclosure to fix the issues, and then the admission of guilt have always been what the commission has determined to be the most important part of the settlement, even more important than the penalty. So that is where the emphasis has been over the years. And then for mainline settlements, there's an agreement to the relevant facts. So obviously, when you see a mainline settlement, sometimes the stories say respondent contends or respondent states, and that's to let them have the opportunity to say their part of the story. And the ones that don't say that are the facts that we agree on. So then that way we flag it for you so you know what we all agree on, what they state, and what enforcement states. So I do think this is a good chance to clarify that I know one of the issues that the public brings up a lot, or the newspapers or the media, I guess I shouldn't even say newspapers anymore, so archaic, but the media brings up is about people being treated differently. And so sometimes you hear, well, this person is super sophisticated, they catch these breaks because they're super sophisticated or whatever. But, the good thing about the commission is that we have already addressed that. So with the streamline, we do have sophistication as one of the elements that we look at. And in the later slides, when you look at the mainline stipulations, we look at the level of sophistication because that is what the commission has told us to look at as one of the factors. But it's only one of the factors. The commission has also said that when looking at certain violations, we would like those to be treated with more harsh penalties and to start at max fine or to really consider that, no matter how sophisticated the person is. So it's a balancing test of the different factors in the different situations. And I know that that's difficult sometimes. And one of the things I say in enforcement a lot is there's no bad guy provision of the act. And there's no good guy mitigating circumstance. So it helps you to keep your personal opinion out of it, which is hard sometimes because you're like, I know this guy, just, so slimy. But you can't let that be a factor in how you consider the criteria and you apply them to the facts of the case. And it's like, it's good for people to vent about that and to get it out, but then go back to what the factors are. And the fairness is in the equal application to everyone the same way.
Can I ask a question about the admissions issue that you
Sure.
raised a minute ago? So if I understood you correctly, I think you suggested that if we changed our policy of requiring an admission in administrative proceeding, we may have more settlements or they may proceed more quickly. Can you quantify that? I mean, how much of an uptick in settlement activity would you anticipate if we changed that policy?
I wouldn't think it would be drastic. I think that some of the people that had considered that at the local level had thought it would really make a difference, but they didn't really have any evidence to show that. I think it's based on the whining level. And what I mean by that is a lot of people say, I don't want to sign this. I don't want to make an admission. I don't feel like I did anything wrong. And with non-filing counts and non-reporting counts, a lot of these are, well, sorry you feel that way, but, the filing officer doesn't have it and you missed 6 in a row, so it's not really in your favor. But I'm not convinced that it would be such a huge thing. I think the ones that have criminal liability attached is where it really becomes the issue. Because then you're saying, sign this, stating that you did this. And by the way, now you open yourself up to criminal liability.
Well, can I ask you about that? Because I may have a faulty memory here, but yesterday we had a significant personal use stip. And as I seem to recall, there was a specific statement in there about there being no admission with respect to any future civil or criminal action. So on the one hand, they're admitting liability for administrative purposes, but not for subsequent criminal and civil actions. So
it was a novel approach. Yeah, it was a novel approach. And we didn't have an issue with including that because they were still admitting liability for what we were charging. And the future will tell whether or not the criminal courts say, Oh, yeah, that's not an admission against interest. So you don't know, and I don't know at this time if that's going to be a viable course forward for other people. But I thought it was very, let's do it. Let's give it a try and see, because you're still taking personal responsibility for your actions, which is what we're asking you to do.
All right, thank you.
If I could, this kind of takes me back to a complaint that I've had off and on for some time about, in the stipulations, we state what the factors are, but we don't say, where this case lies on those factors. And I know some of them are not like black and white, but there's not a lot to guide the commission when they approve these stipulations. It also would, if you were able to provide some kind of information relative to that, it would also help probably have less anxiety about signing these things. In other words, I know one of the criteria is whether it was inadvertence. And if somebody's signing something, they say, I inadvertently did this, they feel a little better about it and whine less.
I completely understand. And I actually took that criticism from you last year, and the more recent stipulations that you have been seeing actually in the conclusion section go through those factors and will address each one of them and whether or not there was evidence to show one way or another on each of the factors. So I would say, like, if you looked at the commission agenda from yesterday, all of those stipulations would have those factors addressed in the conclusion. And I think the attorneys in enforcement are doing a really good job of being able to articulate that. And I think the investigators have changed what they do in the investigation in order to make sure they address all of those factors to give the attorneys exactly what they need to write it up. So it was a good suggestion last year, and I really think that it's come full circle.
And you still get that anxiety about signing because of the admission.
Because of the what? I'm sorry?
Because of the requirement to admit doing something wrong.
Right. I think when there's criminal liability involved, that's when the anxiety exists.
Okay.
And then, so in applying all these factors, as you can see, that streamlines the function of the regulations. And then we always put in this quote about streamline is the offspring of compromise. The question we address is not whether the final product could be prettier, smarter, or snazzier, but whether it's fair, adequate, and free from collusion. And that's really what we use to guide. And as you can see, there's different styles of writing that we present to you. I don't micromanage style of writing. You can be long-winded or short-winded. You can, present your facts and your charts. There's certain times I go, could you please add a chart? I really cannot do a paragraph of dates and when they were due and how much was on each one. But beyond that, we really just try to accept them, everybody with their style and everybody's settlement. And sometimes the respondents want to put in 3 paragraphs of what they feel is their mitigation, and that's okay too, because it's all part of the story, as long as we don't know it's not true. I'll give that caveat. Okay, so that's the overview. So moving on to the enforcement trends portion. So trends are, hey, there's money in politics. Referrals haven't been slowing down. The laundered campaign contributions we've been continuing to see and focus on. What I would say about those, as you'll see later on in the slides, how much resources we spend on that. These are the cases that you don't see for another year because they are still all in investigation, and they're all taking the time that it takes to track down all the people that are participating and subpoenaing bank records, and so the resources that we spend this year, you'll see the results of next year. And then personal use of campaign funds, obviously, you've noticed that we've been focusing on that in 2019. Advertisements and mass mailers, that was a lot of cleanup from the 2018 election this year. And then the campaign-related communications at public expense, we continue to do advisory letters as well as continue on with those cases that are going through the administrative process. So what I would say about complaints and referrals received, as you can see by this chart, referrals aren't slowing down. So referrals include, we receive referrals about campaign statements, SCI statements, lobbying reports, annual fee, gift and gift limits, gift disclosure, and behested payments. So it's a lot of referrals to receive. And some are great, some are not, but some are just sometimes reporting errors. But as you can see, the uptick in referrals is not slowing down. And so why is this? This is really the question. Why is there so many?
Ask a real
Sure.
quick point of clarification. So you're talking about referrals from local filing authorities and, I mean,
Sure, as well.
who's the population of people who refer to us?
Right, so the campaign referrals come from locals and Secretary of State. The SCI referrals come from the FPPC SCI unit as well as locals. The lobbying referrals come from the Secretary of State. Annual fee comes from Secretary of State. Gift comes from, generally from the SCI unit who look over people's statements, and behested payments comes from somebody in this agency. I'm not really sure who.
How many people are in the SEI unit?
That's a good Larissa question. 6 was the answer.
Judicial notice that was 6.
Commissioner Hatch, you had a comment?
Yeah, I was, this question of nature referrals, because I'm a little confused last night reading these as to what that consisted of, and I'm getting a good idea here, but I didn't hear anything about FTB. Are those considered referrals?
FTB publishes audit reports and then sends them to us. So we consider them FTB referrals, but they're more published audit reports, so they have a different classification. It's just like when FPPC.
In your chart, are they among the referrals?
I believe so. I believe that's what they're grouped under.
Thank you.
So I had a couple questions, if it's okay. The first question is, I noticed that the number of referrals spiked significantly between 16 and 17 and has remained pretty steady since then. So was there some significant event between 2016 and 17 that accounts for that?
Exactly what I was going to talk about. So what we started doing was what we call pre-election efforts. And so we started reaching out to every county that had an election and then every city that had an election with a population of over 100,000. And we said, hi, we're the FPPC. And we would like to help you get 100% compliance in your jurisdiction. It was done in 2014, but not as on a large of scale. So in 2016 is when it really started getting a lot of participants, because it's a voluntary program. There's no requirement for them to participate. But we said, listen, you have people on the ballot, you have people that have filed 501s and 410s. Let us know if they are supposed to file a pre-election statement and they haven't, and you've tried to get them to file it, and we will come down on them and get them to file these. And in the 2016 election, we even went to civil court to get an injunction to file. I believe someone at this table may have done that. It was Dave Bainbridge, right, when he was in enforcement. And so it was, I believe that judge also said she could remove him from the ballot. Yeah, that was interesting. But, yeah, okay. And so that's when we started really putting the word out, and then people realized, oh, you guys, we're supposed to be sending you referrals. And so I'll give you an example how the education unit has then doubled down on this and has really gone out and done this education of these filing officers. Humboldt County just contacted us and said that they hadn't tracked their late filers because they always thought that FPPC did it. And so they attended an FPPC workshop, and now they're reviewing their records and submitting back to 2015. So some of these referrals go back several years. And so since they learned that this was what was needed, they're completing the steps and they're making the referrals. And I think that this is the way that it's been happening as the FPPC gets more known and the education division is out there talking to people that maybe aren't aware that they have these certain duties to be referring, then all of a sudden they are. And so I don't really see this slowing down. I see as education remains and people know what their duties are, even when someone else takes that office, then it's in their manual now, and that's part of what they do.
So we have the spike in referrals because of the education and outreach we've done with the filing officers. Percentage-wise, of those significantly increased referrals, how many of them are good, meaning that we would actually open a case and an investigation in?
That's a good question. I have a slide on that. I would make one more note before I move on to answer that question. The referrals are not a bad thing, so we just need the staff to manage them. Half of the cases yesterday presented to you were from referrals. So they weren't necessarily all non-filer cases that you saw. Some were cash, some were personal use, some were all these other things that sometimes you get out of a referral or a non-filer.
Before you move on, because I
Sure.
think you'll answer that more later. I also noticed in the chart that it appears that in election years, we have a significant increase in the number of complaints. I presume that's because folks who are involved in the campaigns are lodging more complaints in an election year than they would otherwise in a non-election year. So when you get to your slide on complaints and referrals versus actually open cases, I just like, in terms of quantifying that, when we have that uptick, how many of those are actually good complaints that we actually open? So you can address that later.
Yes, that's also on a later slide.
May I quickly, the 2019 numbers, Ms. West, are as of what, close of September, October?
November 1st.
Thanks.
So they'll have 2 months additional information in the end of the year report. And that chart that I include in my executive staff report will have 2019 added to it sometime in January.
Okay, so these are, they're calendar year, okay.
Yes.
Okay, thank you.
So when we're talking about the trends, here's just an idea of launder campaign contributions and misuse of campaign funds, the complaints that we received in these years. As you see, it definitely goes up in election years, the complaints received. And then when you look at the cases opened, they're also continuing to go up. The blue that you see, that was for the older year, this is when we opened laundered campaign cases based on our internal proactive programs. So one of the things that the investigators do here, and they do so well, is that we use interns, we use all the investigators and all of the bank scan software and all other things to scan for patterns in local jurisdictions that have limits. And those are the cases that then once we identify patterns, then we gather information from the campaign for the records, and then we reach out and then we evaluate for laundered campaign cases.
May I ask, what's an example of a pattern?
So some of the examples of the patterns, when we had to do motions to compel or defend our subpoenas in Orange County several years ago, we listed the factors that we use for the judge's consideration to support the subpoenas. And what those include are things like similar addresses, similar employers, positions that wouldn't necessarily have the income that would generate large contributions, people that have never given before, people that don't live in the jurisdiction. And so there's quite a few factors that we look at and apply to the criteria in order to find the most likely cases to spend resources on.
So someone has to go through paper and online files mean, there's no like metadata mining here that can be done, right? I mean, this is tedious.
Well, thankfully, SOS is here today, and they're going to have cars at some point, and we're going to be able to mine all the data we want.
I've heard of this.
But yes, you are right. Right now, it's a heavy, intense resource proposition, and so we are very lucky to have a strong intern program for the investigators, and we have them help us with identifying patterns and gathering information and going through statements. We have bank scan software, which actually inputs the information into Excel spreadsheets, which is very helpful once we subpoena the bank statements and other information. So it's a labor-intensive endeavor, but it generally very much pays off in these local jurisdictions where there was significant laundering. Another place we spent resources on would be advertising and mass mailings. That was a trend for 2019. As you know, October 1st of 2018, we launched AdWatch, which was a shortcut way to tell us about an ad that you thought didn't comply with the requirements. We concluded AdWatch on November 15th of 2018, so it was open a month and a half, and we received over 130 submissions. So it was a very successful program. This time, when we relaunch it on probably beginning of January, we'll bring the importance to the people again about reporting ads that they see. And we'll have more internal format that we didn't have when we first launched it. We just thought, a couple people would send in some ads, and then we kind of got an overwhelming response. So this time we'll have more sheets people fill out electronically and put it straight into our Salesforce program and things like that. So we just weren't expecting the onslaught that we received. And then in addition to that, the investigators also looked at over 300 online ads proactively and contacted and got people to change their ads before the election. And we're very fortunate to have a couple of the attorneys at Enforcement Division that have really gone into the weeds on the Disclose Act and the advertising requirements so that the investigators have people to go to right on the spot. So it's all very, very fluid during the election season.
With respect to advertisements and even mass mailings, I wonder if you can just briefly describe what types of violations are captured within this concept of advertisements. I mean, is it the absence of any identifying information, or is it a flaw in the form in which that information has been disclosed? Kind of just break that down for us.
Sure, it's basically everything. So if it's required on an advertisement, then people can just say, oh, this was supposed to be underlined and it's not. It can be something as minor as that, or it can be these ads have no disclosure. And as you can see, this gap between the complaints received and the cases open, if you look at the 2018 number, it's a significant drop from the over 300 to the just barely over 100. And what a lot of that can be, the cause would be, is the discrepancy is because a large number of the ads are from candidate and political party committees, which on all ads that are, here's the list: newspaper ads, electronic media ads, signs, flyers, billboards, door hangers, flyers, and posters, it's elective for them to put even who is responsible for the ad, much less any proper disclosure of, names and paid for buys and all that kind of stuff. So what ends up happening is you're spending a lot of resources on complaints that say this ad has no disclosure, but yet it isn't required to have disclosure, but it takes us the resources to find out whose ad it is in order to be able to determine that. It was something we brought up when the Disclose Act was being considered, and it has become the problem that we thought it would be. The resource suck for these kind of investigations is real, and it's one of the reasons that it's on this slideshow to bring it to your attention. Go ahead.
Just briefly, what is the policy rationale for not requiring or making it elective for candidates and political party ads not to at least have a basic disclosure of who paid for it?
I'm not the person to ask that. I have an opinion.
I think I know, because I think
Commissioner Hayward.
because I think somebody, a member of the public, talked about this once at a meeting a year or two ago when we were talking about the Disclose Act, which is that if it's a message about the candidate from the candidate, there's not that sort of dark money who paid for this ad kind of problem. If it's a message about a candidate from the political party, those are sort of aligned, known political entities. I'm not defending this policy, I just think this is what they were thinking. So as they were expanding these very specific and thorough disclosure requirements, they wanted to do it on the people that they felt were the bigger problem, which is the independent groups, the groups that weren't candidate or party committees. Because the candidate and party committees are supposed to be doing that anyway. Does that make sense? There isn't the sort of finagling, dark money kind of implication to advertising when the candidate is talking about the candidate or his opponent.
All right, so that's the rationale.
I
that's
think
expressed.
so. I mean, we have hopefully somebody out in the world that has a typed, can like type in a little comment. We're not looking at that on the screen right now, but I think more or less the justification I heard.
All right.
Brian may remember more clearly. I mean, it was in a meeting where he was too.
Yeah, I do recall that the advocate for clean money said that they were at the people who were trying to hide their identity, which is not the candidate or the party.
Okay. Go ahead and continue, Ms. West.
Okay. So what I'd like to just give a little shout out kind of to the investigators on the amount of work that it takes when it is an anonymous ad. And generally, they have to issue subpoenas to vendors, Google, Facebook, other online providers, because their policies do not allow for the provision of information without a subpoena. It's very time-consuming. They have successfully tracked down anonymous and misleading robocalls, Facebook ads, yard signs, mailers, websites, tracing the information from the online providers. They've used information from the post office. They've contacted all printers in the jurisdiction to try to figure out if anybody recognizes the ad. They've interviewed the clerks, the opposing and other witnesses, issuing the subpoenas to the vendors, and interviewing even day laborers that were paid to distribute. So it is a labor-intensive job to figure out who has sent out an anonymous mailer. And digitally, very difficult. And in fact, with the $2,000 or $1,000 threshold for digital ads, then sometimes all of that, you finally figure out that they spent $100 on these online ads. So, it's one of those things where if we had even base disclosure on all ads, that would help us out greatly. So then on mass mailings and ads at public expense, the gray is the number of cases open total. And then what I wanted to show you was, obviously there's two types. There's mass mailers that feature public officials, which is the orange. And there's blue is the cases regarding the strict restriction against campaign ads at public expense. And as you see, we issued a lot of advisory letters on this topic. And the reason for that is applying the regulation and seeing what comes up to the line and what doesn't even come close. It's very clearly educational materials that fall under the exceptions. And so for all of those advisory letters, those were ones that we felt we had to put the jurisdictions on notice and say, listen, we looked at your ad. We're a little concerned on how close you're getting to the line. Please be careful in the future. So I think that was a good way to handle the first round of these in 2018. And then the ones that we did stipulations on or they're still pending are the ones that we were more convinced that there was a disregard of the rules.
And how's that being taken? What's the reaction you're getting there?
If you're thinking I'm going to say appreciation, that's not the right word. It varies from jurisdiction to jurisdiction because some jurisdictions just say, oh, thanks, we didn't realize. And then other jurisdictions say, well, we didn't break the rule, so there you go. So it just depends on each jurisdiction's different.
And in that, communication, you let them know that if they do cross the line, that they're gonna have to start filing as a committee?
Yes, it actually has a quite large law portion in the advisory letters.
Good. I like that.
And we have one attorney in enforcement that handles the writing of those letters so that it's very consistent in its treatment. And if anyone else gets assigned one of those cases, they consult with her to make sure that we're all on the same message. I'm telling you, we just got great people. So on to resource allocation. So what was prioritized for 2019 and what should be prioritized for 2020? That's supposed to be a badge. I don't know what it looks like, but yeah. It didn't look exactly as I planned.
The chair says it looks like a toaster.
Oh,
I might just be hungry. I mean,
it's a sad human being toaster.
And some of us think we don't need no stinking badges.
Yeah, exactly. So this kind of goes to the questions from earlier. So the 2018-2019 differences. So if you look at the election year, the blue is campaign. And then you look at the non-election year and the orange is SEI referrals. So huge difference. So, and this is a very typical pattern, and you'll see this basically in every 2-year cycle. People clean out their non-campaign referrals generally. In the off year, we handle the cases that are left over from the election, and then it starts anew the next year, or in December of the year before now. Not that I'm bitter. So drilling down, we used to have an off year. So drilling down into what kind of campaign cases are opened. A phrase I said I would never use, but I decided, go with the crowd, drill down. So annual fees are still a larger chunk. And we will at some point in some year determine what we're going to do with those. But as of now, we are proceeding with just getting the annual fees included into cases that are campaign and getting them hopefully paid in any settlement so that the SOS becomes whole at the end. And campaign non-reporters, you see, those are a large amount of cases open because sometimes with complaints, they say something, but they mean something else. So they file a complaint and they just kind of go, I know something's wrong with this. And it's, this guy's doing something wrong. And it's like, oh, well, yeah, they didn't report. They don't have a Schedule D. And all they did was campaign, supporting other campaigns. But I know, I'm getting a little nerd out there. Oof, pull it back. Okay. So then other campaign and then laundered campaign cases were another larger chunk of what was opened. And then this is one of the places that we spent our resources. So we were prioritizing the complaint processing. So I've used median because median is more accurate than mean or average because it takes the middle point and gets rid of the outliers. I'm sure everybody knows that because everybody's a math nerd. But, and so we wanted to show about the days open for a complaint. So it was in 2018, 10 days, 10 working days. And, sworn complaints have those statutory requirements of how quickly they have to be handled. But non-sworn, anonymous, commission-initiated, they don't have those timeframes. So these are self-inflicted timeframes, as we call them. And so what we did was add that fourth intake position, and it went down to 6 days. So we've really helped by adding that position. We got 2 positions in the last 5 years, and that's where we chose to add that because it is such an important component. I mean, as Commissioner Cardenas was pointing out earlier, having well-trained, sophisticated staff at that position is essential to the working of enforcement because they have to handle not only the complaints they have, so they do a week on and then 3 weeks off kind of cycle. And then they have to handle all the complaints that they received during that week and referrals. And then the ones that stay with them, because they just need a couple of amendments and they can get a warning letter or streamline possibly, then they have caseloads of 120 to 200 cases. So it's a high-pressure position, and adding that fourth position has really helped take that extreme amount of pressure off, which is, I think, essential. So, if we ever could get a fifth, then maybe I'd see them smile every once in a while. Who knows?
Can I ask you a question about prioritization?
Sure.
In an election year, looking at the chart of types of cases opened, it's pretty clear in an election year, a majority are campaign-related. Then you have your SEI and your others. In election years, given the arguable time sensitivity to resolving those, do you prioritize campaign-related complaints ahead of, SEIs, for example, during an election year?
We do, with the exception of candidate SEIs. But yes, we do have that practice, and that is something that we have done the past 4 years or so. And people know when it comes to campaign season, your older cases are probably going to sit because if they're not relevant to this campaign, you're going to be assigned cases from the 2020 March primary, and you're going to have to work those right here and now. And so with our compliance program, the attorneys get involved when the intake staff and the support staff are having no success getting them to file their pre-elections before the election. And then the attorneys get involved and see if they're going to have to do a civil injunction or something else more convincing for that person to actually file before the election. So it is really a team effort when it comes to gearing up for an election. And unfortunately, that means some other cases have to sit because the priority becomes the campaign cases.
If I could, are we still on slide 19?
We can be.
Prioritizing complaint processing. It struck me when I was going through these several slides that the dramatic difference in the reliability of the information that you receive for referrals versus complaints. Complaints are rejected at a much higher rate because of assuming the quality of the information is good. And I had a couple of suggestions that I wanted to offer. I thought it would be helpful if we could get IT to develop a web-based self-screening tool for making complaints, another like a questionnaire. When you make a complaint, instead of filling out the form to begin with, you start with questions, a series of questions that would then help determine whether this was really a valid complaint or whether they just misunderstand the law. I know with some tedium to get it developed, it would be a big time saver and cut down on the number of complaints that you'd actually have to process. Sort of maybe the tool would allow them to realize that they either have a complaint or don't have a complaint. And also, I think some short educational videos on the web targeting the categories of least reliable complaint history. So you look at backwards and say, here's the ones that are most misunderstood. Let's do a couple videos on those. And also, I thought you may already be able to do this, but can they, in a complaint, can they attach electronic copies of documents that they want to underscore their case that they want to pursue?
Yes, actually, they do file the attachments with it. In fact, for referrals, they're required to file attachments with it. With complaints, it's up to them whether or not they have any proof or different items. Generally, people will include campaign statements and things like that. I agree with you. Anything that we can do to help people when they're filing complaints is a great thing. One of the things we did when we started the electronic complaint system is we made a list of 7 or 8 different violations that are outside the act, so that if they chose that, then a pop-up would come up and go, hey, this isn't the act, you got the wrong people. And so then suggest to them where they could go for that. And I think that has really helped out for like people living outside the jurisdiction. That was one that we would get all the time. And so now when they click on that, they get the message, and we're not receiving those anymore. So, very, very few. I mean, sometimes they're going to pick something that isn't even close to what they're saying, and it's still going to be not under the act because you can't really shoehorn it into something else. But I think for those people, they're not going to be deterred no matter what. They're just going to file their complaint. The short educational videos, I'm glad you brought that up because I know TJ brought up, Executive Director Jones, that we're talking about in the education realm doing those. And I'd actually spoken with Jay Warmenga a while back and asked him if he would be willing to do a couple for the enforcement complaint page because we wanted to explain some of the things that people fill out wrong on the complaint form or, short little things saying, hey, remember, living outside the jurisdiction is not under the act, and say it in a golden voice so that people will listen. And that's what I was hoping for. But he used to get paid for that voice, so I'm just saying we should use it. So so I totally agree that continuing to improve as we're trying to do with the complaint form is exactly the direction that we want to go.
Yeah, the interview format at the beginning, I think, would be most helpful because those kinds of questions that are going to separate the wheat from the chaff. Well, I think cut down on the number of complaints that are invalid, and there's so many. It's just a tremendous strain on staff time.
Yes, I agree. So Christmas present should be sent to the 4 intake staffers. No, I was kidding.
Thank you.
Under $50, obviously. Okay, so then we'll talk about, I think we're on 21, right? So where I left off, referrals received. So this is talking about, I think one of the chair's questions earlier about referrals. So they do often lead to more serious violations, but our rejection rate for referrals has increased because of more people participating in making referrals, however, not necessarily educating themselves as to what a good referral is. So one of the solutions that we're talking about is we'd like to come up with guidelines for filing officers for referrals, not just the required fields that we have, but also, hey, could you find out if that commission still exists? That would be nice. We'd appreciate that. And not give us referrals for everyone that was on it in 2002. But, some basic guidelines as to what is an acceptable referral that's not going to cost us to try and figure out if that charter school still exists or whatever. So we really want to try to educate a little bit more now that they've gotten that base education that these duties exist. Maybe we can also give them some more information so that they can know what they should be sending us and what we're going to be able to act on, because I doubt that they want to spend the time sending us something that we're not going to act on.
Yeah. On that chart, the 2019 has got that 6% for intake review, and there's no such slice in 2018. Is that like a new?
So intake review, since these are numbers that are from this year, so there were some, so this was run on November 1st, so there were some that were received on November 1st, so they're just still being reviewed. So that's why you didn't see it for 2018, because if we still had referrals we were reviewing for 2018, that wouldn't look so great. So, but for 2019, it's more understandable. So then I think this is about the conclusion of this category. Oh, I know, I got one more. So for this one, I just wanted to try to show that the first 3 categories are the more serious violations that we focused on in 2019. I said 2018. Resulting in many successful prosecutions this year. And other areas that we spent resources on are pursuing the non-filers. So as the commission knows, I don't know if the public knows, but we filed a civil injunction to successfully force a sitting school board member to file his campaign statements that he had refused to file for 2 years. And he did. So once it went through the civil courts, then he filed that. So That was very successful, and one of our attorneys, Chris Burton, handled that and got to make many trips to, I believe it's San Bernardino, and he's really grateful. And so, and then Bethesda payment referrals have risen over the past 2 years, and we received approximately 30. We'll talk about that more later in the slideshow. And then we've been working on the contract work, which has also been taking resources. The City of Sacramento audits are concluding, and they should be coming to me for evaluation for possible prosecution. And then, as we mentioned earlier, process 7 defaults this year. So we're continuing to spend those resources to go after the people that refuse to participate and refuse to file, that won't take responsibility. And then I also put CPRAs on here, which is California Public Records Act, because, you know, everybody says PRAs, and that's a political reform act, so it gets a little confusing, so we call them CPRAs. And that has been a huge uptick. The legal division took on the project this year to start tracking those as an agency instead of just as individual departments and within the agency. And so they're going to be able to have the statistics to show the workload of CPRAs. And I think it's going to be shocking because the amount of Public Records Act requests that enforcement responds to is enormous. We actually have a position that I would say half to 3/4 of our time is processing for the enforcement responses.
So can I ask a point of clarification then? So when our agency receives a CPRA request with respect to an enforcement matter, it's enforcement staff that's calling the records and responding to that? It's not the legal division?
Right, because they don't have access to them. So the legal division, because of the ethical wall, doesn't have access to Salesforce and our programs and our file room. And so we have an employee in enforcement that generates the records and provides them to the legal division coordinator, who, if it was for an agency-wide CPRA, will coordinate that response. And if it was for enforcement, she will either say, please go ahead and send it, or I'll send it.
All right. And in terms of workload for enforcement, is that, I mean, on an annual basis, at like 1 FTE? I mean, how would you quantify that?
I don't know what FTE is, but I do know it's one person.
One employee spending
Yes.
full time through a year
So
just on
all the non-senior attorneys take a turn at the CPRA duty, and they focus their time. So if it's, sometimes it's thousands of pages because, you know, case files are huge. So we have one attorney who is severely unlucky every time it's her turn. And then we have others that are super lucky. So I would say on average, it takes quite a bit of their time. I would say 1/4 of their time when it's their duty month. And I think they do 2 months at a time. And then the employee that does it is, it can take up to almost all of her time, because then she processes SCI referrals in her spare time. And I can see the difference on the number of items I receive from her for SCI, regarding SCI, on how much time that she's taken doing CPRA responses. And sometimes I receive almost no SCI work because of how time-consuming it's been. So it would almost be a full position for sure, but it's kind of split.
I have a question about, isn't most of what you're doing with processing these documents exempt from public records request?
The short answer is I wish, but no, it's because we're not an actual law enforcement agency. We're only a quasi-law enforcement agency that some of the records are available for the public release.
You haven't put to us yet? It's in process?
What do you say?
Can you clarify,
I'm saying,
clarify your question, please?
About in-process work that hasn't been presented or to the commission or for approval?
I see what you're saying. Most of our requests are for closed cases, and that's when it becomes a lot more workload. For open cases, it's what we provide is actually in the regulation under the media policy that the commission approved, which is a copy of the complaint, a copy of the response, and an opening letter or a rejection letter, or if there's a closure letter for the case. So It's dictated by what the regulation says, which is one of the regulations that we are thinking about revisiting later on next year. So that would be an opportunity to have this discussion again.
Yeah, it seems like we could maybe tailor our rates to reduce the workload on this area. It just, yeah. Frustrating to me that often the media gets lazy and they just use this process to have you do the research for them.
Yeah, it's a plus and a minus. I would say probably 12 years ago, enforcement didn't confirm or deny about even an enforcement investigation going, and they did not respond to SEPA requests. So it was the balancing test, the quasi-law enforcement using that exception under SEPA to protect those documents. So the pendulum has swung back and forth over the years.
Just so I'm clear, so just historically then, the agency internally took a position previously that under SEPA, under the balancing test, that we would not produce or respond to those requests. And then the agency, as a matter of internal policy, decided we would not continue to invoke that exception. But the court, so where do we stand in terms of the courts? I mean, could we invoke the exception and have it stand up in court? Do we know the answer to that question yet?
I believe there's a Mercury News case that said we have to provide something. I would have to go back and look at it. Do you remember?
I don't remember that case off the top of my head. Yeah, there has been case law in recent years that has kind of probably pushed the pendulum the way that we've gone, but nothing right on point.
So accepting that, hold on a second, Commissioner Hatch. Accepting that representation then, Mr. Bainbridge, so it sounds like our path going forward really is how do we manage the workload of redacting and sussing through the various documents that would be subject to disclosure, as opposed to trying to revert to a policy where we don't turn anything over?
If we would like to avoid the risk of a lawsuit, yes.
Yeah, we generally
that would be the,
like that.
Right. I certainly do.
Thank you.
So
Okay, just a moment. On that point, would it be worthwhile to get ourselves by legislation recategorized as a law enforcement agency that can keep these records confidential?
yes, that would work. So since we're not considered law enforcement, that is why we don't get that exclusion under SEPA. My understanding is it's very difficult, but I mean, I wouldn't say no.
Okay, thank you.
And just to point out, that regulation did not exist before I got into this job. It was a priority of mine to get it as a consistent media policy and what we disclose to the public. And so we did that within the first year. And Legal Division was very helpful in getting us that regulation passed so that it's a consistent policy, which is one of the things that I found to be a priority when I took over. So this is the last slide of this resources. I wanted to give median case pendency numbers that show really how long a case takes. So days open, the median number is 105, with some of them being a lot faster and some of them not. And this is, days open means from the time it's first open until it's either approved by the commission or the case is, and the case has to be ultimately closed in the database. So no fudging of numbers. You can't just close something and then be like, I'll do the database later. It's like, no, the database is in charge of your numbers. So so everything is a very consistent treatment. And then as I pointed out earlier, while the complaints and referrals hold steady of a rate of 3 times of what they were just 4 years ago, and our advertising workload has increased dramatically, our enforcement staff has grown very little. So we got that intake position, and we've also received an attorney position. There are some limited term positions that have helped us because we've had significant long medical leaves. So Larissa has been great in helping us fill in for people that aren't present right now, and so that's been really helpful. But to actually gain more positions would help us significantly. And suggestions for 2020 would be to continue to prioritize these ones at the bottom of the chart, the money laundering investigations, the campaign mailers, the public expense, and the conflict of interest. And as you see, these ones at the bottom are the ones that take the longest because they're the cash, they're the commingling, they're all the ways that you can hide money. And so these investigations take much longer. Settlements take much longer. You're usually going much further through the administrative process in order to get these cases. You're issuing PC in order to toll statutes, you're writing accusations. And so I think that these numbers realistically show what it is and how it takes. And so one of the things that I wanted to kind of go over is cases that face slowdowns, why would they be delayed? And to give you some understanding, it's we have uncooperative witnesses, we have service problems, service evasions, we had disagreements regarding what the required production is. We have production delays, vacations, extensions, because it doesn't seem like a big deal to give a 3-week extension, but then when they don't produce at the end of the 3-week extension, and then you're doing your motion to compel, it's all said and tacked on a little under 3 months already. And then changes in representation, multiple parties and allegations, that's a huge one. When you get some of these cases where the allegations are about an entire board and you have multiple parties and everybody's represented by somebody else, these cases take a while. They can have an audit pending with FTB, so we can get a complaint about a time period where FTB is already auditing, or FTB's issued an audit report and then they're going to issue another audit report, and so that sometimes causes a delay. And then staffing. I wanted to bring up that the attorneys currently have a caseload on average of 60. So they have 60 cases that they're not only help ushering through the investigative process, but also prioritizing working onto a resolution. And that's too many cases. It's just, if you have just one large case, like for instance, I have an attorney whose case is going to hearing at the beginning of December. How is she supposed to balance that with also keeping her other cases moving while she's preparing for hearing in December? So you prioritize getting these cases to hearing and pushing the defaults through and doing these civil actions. But when you realize that there's only 9 attorneys in enforcement, then if you take 1 or 2 of them out of the game to do one of these things, then everything else takes longer. So it's always a balancing act, and we struggle to always hit the right balance and to be able to handle things as quickly as possible. We help each other out. We transfer cases and say, this one's ready to write up. Do you have time? And so sometimes I'll ghostwrite a case, whatever it takes to keep things moving. And so we do have some suggestions for improvement. We can change rules regarding service so that we can electronically serve, and we have to rely a lot on process servers. And as you saw in the last default, there's a lot of difficulties in serving certain people, especially people that are no longer on a board or a board that doesn't meet very frequently. And also, by not being law enforcement, then it's hard for us to get a lot of the job information, current job information. And then we want to improve communicating for some of these older cases that sit, so possibly instituting something to where we do more reach out when a case is set for 3 to 6 months and say, hey, we're still here, we're still alive, I'm doing this hearing, but if you have anything else to produce, I just wanted to let you know I'm going to write this up as soon as I can. But just so that we have that communication. And then obviously, continuing to improve case efficiencies and shortening delays, not accepting, I can get this to you in 3 months. And so we do push back and we try to get as much cooperation as possible. But without issuing a subpoena, then you have that difficulty of you're trying to get voluntary production, which is what we're told to do. And so we try to balance that out with how hard do you push in order to get the documents quicker before you issue a subpoena. So those are all just the considerations I wanted to bring to your attention, that these are the things that happen daily When we have case reviews, we talk about them and we talk about getting over hurdles and ways to go around and things that we can do, easier ways to serve, things like that. So it's always a process. So,
This median case thing, this is a 3-year chart, and so the only item that's above the line of 105 is SEIs. Does that mean that the volume of SEIs processed is equal to or roughly exceeding all of the other bars on that chart?
I would say so. I mean, there's hundreds of thousands. I'm sorry?
I was just surprised that there's so many SEI cases.
Yeah, me too. Well, you know, it's every board, it's every agency, our SEI unit's on top of stuff, and so they make their referrals and they do their job and they do their part. And you're talking, what is it, 100,000 SEI filers? What's the number?
Throughout the state of California?
Yeah.
900,000.
900,000 SEI filers in the state of California. So it's an enormous workload. And, you know, some of those cases are the cases that then bring you your conflict cases. Because sometimes you don't file your SCI because you forgot, and sometimes you don't file your SCI because you didn't want to disclose your interest. So, you know, you never know until you get them to file.
Yeah, and not all of those 900,000 come through our system. They're local filing officers. And state agencies as well have their own filing officers, correct?
Mm-hmm. Yes. Sorry, I was nodding.
Oh, sorry. Can't see that. Okay, thank you.
So I don't know if you want to take a break before we move into penalties, but
Yeah, why don't we take a 10-minute break?
yeah.
Yeah, 10 minutes. Thanks.
What's more issues, honey?
and then have them on the trial. How would that potentially work in a larger trial? Could you replicate that in phase 3, or if you want to see more from the real world type setting, testing this in a large?
Oh, absolutely. So the phase 2 design really is going to be pretty much what we do in phase 3, with probably a large number of patients.
Ihele Akahua.
All right, we're going to go ahead and reconvene the meeting. Ms. West, floor is yours again.
Now that everyone significantly missed my voice for 10 minutes. So we'll move on to penalties, how we instituted penalties in 2019 and suggestions for 2020. Talking about general categories, so the criteria that Commissioner Hatch was discussing earlier, as well as we're going to talk about 3 specific categories: the conflict of interest, the personal use, and the use of cash. So the general categories are the first 7 boxes, which is from the regulation, and these are the ones we address in each stipulation. And then over the years, the commissioners have emphasized certain areas. And one of those areas is consistent treatment, and it's something that every commission has agreed on. So we include comparable cases. And when we do include those comparable cases, we try for them to be within the last year or 2, so they're within this commission's purview, so where it's something that they've already seen before and a penalty structure that they've approved in the past. So that's always our goal. Obviously, there's some that are, oh, we haven't prosecuted this in 6 years, so I'm sorry, the comparable case is from 6 years ago, and this is how we've extrapolated from other cases recently prosecuted. And then the one on the bottom, the sophistication of the parties, has been emphasized in the past year to 2. And so it's something that we have put into our criteria of something we consciously think about in the investigation as well as during the resolution phase. And so now the investigators include in their reports what they have found out about the person, the committee, or the players, and how involved they are in politics, what their experience is. And so that's more of a background that they're transitioning into giving in each case.
Question. In terms of prioritizing cases, in terms of case management, do we prioritize those cases where there's an obvious intent to violate the act?
Certainly, and obvious, there's not too many of those, but intention to violate is usually found more during the investigation. It can be something that's alleged, but it takes us a while to prove somebody intentionally violated, because that's a evidentiary-based accusation. So when it gets to the investigation stage and it starts to come out that this is more intentional behavior, then we prioritize it at that time But in the beginning, very difficult to differentiate those at the complaint stage. Does that make sense?
Yes, it does. I'm sorry, I guess you didn't hear my answer. I said, thank you.
Oh, you're welcome. So, so the three that I've chosen to talk about have been three that the commission has brought to light in the last couple of meetings or the last year. And so conflict of interest violations have been a hot topic. And so these are the aggravating and the mitigating factors that we generally apply. I would just point out the large personal benefit received is a huge aggravating factor. And then the mitigating would be the interest was already disclosed timely on their SEIs and they took corrective action before the complaint's filed. So sometimes what happens is someone votes on something and they realize they had a conflict. And so then their commission will dismiss that vote and re-vote. And so a complaint will still get filed sometimes. And so we do take that as a mitigating circumstance. So one of the things that we have as proposal moving forward is that when there is a large personal benefit, then we start at max fine and we use mitigation to reduce if there's any mitigation. And I think that that's really the message that the commission has sent loud and clear in the past 6 months or so, that that was something that you would like to see. And then, and always is a discussion about when it is acceptable to reduce counts for conflict of interest cases, because as we gave some examples a couple months ago, you can have 60 tiny decisions or things that have been signed warrants and other things, or you can have one giant decision. And so I think in trying to figure out what the proper or penalty amount that is appropriate, it's always a struggle with these cases because conflict of interest cases are so fact specific. So the guidance that the commission gives us at each meeting is what we use to base those for the coming year. And so this guidance has basically been, if there's personal use that it has a personal benefit to them or their spouse, that's going to be something that we start at max fine and we reduce from there.
Mm-hmm.
So personal use of campaign funds, we definitely consider the amount and the reimbursement. And one of the things that I would point out that we take into mitigation is, say it's a $6,000 campaign, the $6,000 all came from the candidate, and then the candidate was like, well, it's my money anyway, I'm going to just take it back. And so sometimes we consider that because that happens, and I can't even just tell you, say it happened once. I mean, it's happened quite a few times. So when you say personal use of campaign funds, yes, red flag, 5,000, but we do understand there's other circumstances. So our general philosophy going forward is 5,000 max penalty unless there's severe mitigation. One of the things emphasized by the I'm sorry.
Do you find that there are a number of those, that category of complaint is that the person didn't know that he's not supposed to spend campaign funds and stuff, or do you think most of them know?
I'm going to answer what I think you said, and it's that he or she generally put their own money in and they think it's still their money. And that's generally what their understanding of the rules is. Well, that's my money and it's still my money. And people didn't vote for me anyway, so I'm going to go home.
I was speaking more to the larger group. In other words, of the cases that you get, are most of them people who just didn't understand that there was these limitations on what you can use the money for, or do you think it's largely intentional?
That's a good question. I had to think about that because I think in the larger context, when it becomes a pattern over the years, I think they know they shouldn't be doing this. In fact, in a lot of cases, you see the reimbursements throughout the years because in a lot of cases they go, oh, I shouldn't take that money. Oh, well, I need a little more. And so you see kind of the pattern. And then in other cases, they feel entitled to the money in some way, so it's more justified in their head. So it's always interesting to talk to people who have personally used money, because there's some sort of justification in their head as to why they were entitled to that money. And so some are very upfront about it and some aren't. But as to, do they know the rules? I think the ones that didn't disclose it properly on their campaign statements knew the rules. I think that's probably a safe bet, but the ones that report it, maybe not.
I had a question for you.
Thank you.
Separate and apart from the level at which you begin with respect to the penalty, with respect to personal use of campaign funds, and also with respect to receipt of cash and some of the more serious violations that we see, do you factor, as part of your calculus, do you charge those types of violations differently? So, for example, instead of consolidating, if somebody makes personal use of campaign funds on 10 occasions, I think I've seen you consolidate those into a single count sometimes. Do you also sometimes charge those all separately as an additional deterrent for those serious cases?
Certainly, because filing a civil action, it takes resources. So for us to try to get to the level of whatever the personal use was, or to get the payback plus a penalty, it is very case specific on if you're going to charge 1 or 10 and what that mitigation is. And, there's some circumstances where you're understanding more of how things happened and unfolded, and applying those mitigating circumstances in determining the counts is what we try to do. From how the commission has said, we want to make sure that personal use cases hurt. And so that's why I understood what the people were saying yesterday, because we all agree with that. We all agree that this shouldn't be you zero out. It's just no big whoop. It should be to a point, and that's how we approach those cases, is how much was the personal use, how much was the personal benefit, and then sometimes it's how much can we prove, and how strong or weak is our case. And I think that's the unspoken thing that we don't really talk about when we talk about stipulations, because when I'm presenting a stipulation to you, I don't say, we will never win, please approve this. That's not really a realistic thing that I'm going to say, because if you don't approve the stipulation, I then have to go prosecute that case and through administrative hearing. So there's all those factors that we then have to weigh in. And so sometimes I just want to say, this is the best we're gonna get here. But it's just that implicit knowledge that sometimes cases aren't as strong as the story says.
I have a question. Oh, go ahead.
So the 2 personal use cases that we had, STIPs that we had yesterday on the agenda, I believe, if I recall correctly, both of those individuals were acting as their own treasurer. And it seems to me there's also sort of maybe they feel like they're justified to the money for some reason, but maybe they also just think that nobody else sees the checkbook, so who's going to know?
Right.
And I'm wondering if that's true. Do we see personal use cases involving individuals acting as their own treasurers? Is that like a factor that we see a lot? Is it just, or am I just looking at something sort of anecdotal and trying to make a bigger picture out of it?
No, I think you're correct, because both of those, as well as the comp that was cited, I believe Mark Peterson was his own treasurer. I think if you go back to Shirakawa, he was his own treasurer and he had his gambling debts. And so I do think that there is this lack of check that happens, and that's when it's more prevalent. It does seem that if you have a professional treasurer, or you have somebody else that's kind of looking over your shoulder and asking you about those expenditures, they'll still happen if you're covering it up, but it's a lot harder for you.
Ms. West, I'm really interested in the psychology of wrongdoing. Yes. Yes, I believe I can narrow that. Next, I'd like to investigate the meaning of life with you.
Great. We're going to be here a while.
Well, you assume that at least one of us doesn't have a ready answer. But I want to endorse the no big whoop standard that you just articulated. But first, I want to try to understand it. In your experience, when we see this type of wrongdoing, the Kanciamia case from yesterday is striking. And I was talking about this with Luce on your staff earlier today. Is it your sense that this type of wild wrongdoing, when we catch it, does this just seem to occur to people in the middle of their career, or if we bust them toward the end of their career, or do you, in your experience in your staffs, and this is what I'm really trying to get at, I think. Do you sense that this is an insidious kind of creeping and growing darkness within the individual? In other words, do you see a pattern of taking a little bit here, a little bit there, a little bit there? I mean, some cases you're perhaps prescribed from going back beyond a certain point in time. But I'm just wondering, is there a what's the term that they use in criminal investigations? Is there not a stereotype, but what, someone help me with the term. No one watches detective TV? Profile, thank you. Is there a type of profile where you see this? Does it creep up on them, or do they just snap?
Or they just built that way?
Yeah. There's a variety. I mean, if you go back to the Kinney Durkee cases where she had financial trouble, and so she was robbing Peter to pay Paul, I think that snowballed. You go to Shirakawa, who had gambling expenses, personal issues that they're having. There's other circumstances where they had parts of their lifestyle that they didn't want other people in their life to know. And so you have those circumstances where this becomes the option. And I think that is the more prevalent profile that you see, as opposed to, I'm just going to take this money. But then I think you also see the people that feel entitled to it. It's their money. And so they forget about the public trust, and they forget about the donors, and they just, well, that's my money. That's my pot of money. And so then it's easier to legitimize taking it.
Should we be considering proposing legislation to eliminate the candidate being his own treasurer?
Interesting. I think you might have problems with the smaller campaigns where asking somebody to sign on as your treasurer is quite a commitment. The treasurer duties are extensive, and we require a lot of due diligence. So I don't know if that would inhibit people from running for office. I'm not sure.
It seems like if they can't find one person to trust them, then maybe they shouldn't run.
No comment. Moving on. Okay. So cash and receipt of cash, as we started discussing, this is something that the commission has emphasized in the past year. For the lower violations, we added this to streamline, because there are some instances where cash expenditures of cash and receipt of cash happens. Commissioner Hatch used the term inadvertently. I basically think you have to trip and fall on something for it to be inadvertent. So my standard for this is a little bit higher, but warning letter consideration if it's less than $500. And then excluded from streamline, on the other hand, if it's not reported, the percent exceeds 25% for the reporting period, the total amount exceeds $10,000, personal use is involved, or there's record-keeping issues preventing us from validating it. So the streamline is very strict in what it includes, and, and justifiably so. So then once you see it in a mainline stipulation, the receipt and expenditure of cash, you see a lot of times with other violations, because generally if they're receiving and spending cash, then they're not keeping the records to support that, or they're not reporting it correctly. Because once you start dealing with cash, it causes all sorts of other problems. And no, I wasn't going to throw the microphone at you. And so we really try to consider that as we look at these cases. And you've seen more and more in response to the commission's interest in this. This has become a separate charge. We used to use it as an aggravation of other violations, and now we've been separately charging it. That's why the penalty is not extreme. The range has been between $1,000 and $2,500 in this last year. And it's generally because it's not a standalone violation. So we're also charging the record keeping or the campaign. So I would say in the future, we would just look for more guidance from the commission as to if we're comfortable with how we've been charging this, and if these amounts that we're using for the penalties are appropriate. So we'll move on to the streamlined warning letter discussion. Everybody good? So something I found out, you get to change these little icons on this. I didn't know that. So that was really exciting. This is a learning opportunity for all of us. So major donor committees and behested payments, I put into this discussion as just showing you the criteria that could be used if we wanted to include them specifically into the streamlined program. And then we'll talk briefly about what's working and what needs some review. Winky face, mustache. So it's not you. Well, I did like it, so that should mean something. So, we stayed consistent this year. 77% of our cases went through the streamline program as opposed to mainline or default. And I was surprised. I thought with the addition of the other violations that would go up. And I think maybe that's why we just need to review a little bit what has been excluded from the streamline program to see if we need to tweak some of the threshold percentages and maxes and minimums as to what went into streamline and what had to be mainline. I know I'm going to hit that a million times. So extending the categories, I think, worked, because the committee naming, the cash, the ads, the record keeping, the gift limit violations, I think that those have all been pretty standard and easy to apply. The great thing about the streamline being in the regulation is there's no surprises. We can just show it to people and here, this is where you fall in here, and it's all in the regulation. It's a little harder for me sometimes, because then I'm like, well, I'm sorry, the streamline program talks about what is excluded from the streamline program, and that's set in stone, and so I can't include you in the streamline program, but I do have discretion to exclude you from the streamline program. So, I think some people struggle with that, but it's a bright line rule. And then it causes a greater efficiency, which is what we're looking for. So what needs to be reviewed? The level of detail. So some of the exclusions were regarding 24-hour reports. When we look at the regulation, I'll be able to give specific examples as to ones that were excluded because they were, say, received $1,000 out of a $6,000 campaign the day before the election, so it didn't get filed until the day after the election, excluded from streamline. So, there's certain circumstances that I just want the commission to be aware of, so they know that these are the types of cases that are being excluded. So I would say some of the scenarios that I would bring to the commission's attention are some of the population thresholds on the bottom part, the bottom section of the population exclusions have been found to be pretty strict. So these small campaigns where one pre-election has almost all of their activity is excluded from streamline, even if it was filed before the election, because of the population threshold. So we're talking of, like, for instance, you can have a population of 9,329 in your county, and your activity threshold is $4,000. So if your one big report had more than $4,000 of activity and it was filed more than 1 day late, I can't get you in Streamline. So I'd say just things like that. We need to discuss further as we go along and deal with these regulations. And, but other than that, I mean, adding major donors and behested payments is what I'll talk about on the next slides. But really just the tweaking and the reviewing is, I think, where we're at. And Legal Division has kindly agreed to put us on the reg calendar. So I know Dave's really excited to do Streamline regs. You didn't get an opportunity to do it the first time, right?
I think I did, unfortunately.
It was a monumental task, the one that we did. I think I'm pretty pleased with this.
Yeah, so what we're going to try to do is just improve it. So that's our proposal for working through it. I don't know if it's actually going to be done in 2020 with the election. And I mean, we have a giant gap between primary and general, so maybe. But yeah, so we'll just have to see where it fits in, where the commission decides to address it. So sure.
Question. In terms of the areas that you've identified for review, particularly level of detail and the exclusion for 24-hour reports, is your experience been that essentially that the way the current regs are written in those areas, it's too rigid, and that perhaps a better approach would be to provide more flexibility to you to determine kind of on a case-by-case basis, a weigh-in of factors, whether something should be excluded or included within Streamline? Is that kind of where you're suggesting we think about?
Yes, or to add a different threshold in that to where there's also a monetary threshold or something that isn't just like if the report, which could be $1,000, falls into these time restrictions, then it's excluded. So I think there just has to be something that balances it, whether that be discretion or an additional criteria that limits that blanket exclusion.
Okay, thank you.
So these are just two examples of things that I would suggest to be added specifically. So major donor campaigns are in Streamline in general, but they're different animals. So one of the factors that I'd point out that's different than everything else is didn't receive any notice of filing obligation. So as you know, campaigns at $5,000 are required to notify you and say, hey, thank you for participating in a California election. You possibly could have a filing requirement if you blah, blah, blah. So we're thinking about these kind of criteria to apply in order for them to be specifically addressed into the Streamline program. And obviously, these are just criteria that we have found to be probably what should be included, but it's ultimately your decision. So we would just make that proposal in the regulation. That's why I wanted to bring that to your attention.
To clarify this slide, you say no notice, that's when the campaign did not, as required, provide the notice?
Yes.
Right.
And if they've never filed before and they receive no notice, then that's pretty compelling.
What would a typical fine be like? Like, suppose that you have a major donor who's under the $30,000 threshold. They had no notice. They've never filed before. They filed immediately upon being told that they needed to file. What would be the typical fine in Streamline for somebody like that?
I'm glad you asked. This was actually a comment letter that you received a while back where someone that had been making complaints about major donors' filings was dissatisfied that a lot of these were getting warning letters. And they were getting warning letters because they had no notice, they had never filed before, the amount was under $30,000, and they filed after contact. So these were the factors that we were applying to handle those complaints. And so that would be what we would promote going forward as a warning letter.
Makes sense.
And then behested payments, I think, is the other area that's ripe to be included in the Streamline program. Now that we're receiving more and more referrals of these, I think one of the large factors for exclusion is business before their agency or a perceived or real personal benefit. Those are the ones that we would suggest being excluded from Streamline. And those are the ones that you've seen as mainline STIPs in the past year as well. And all of these other factors are just suggestions as to things that we've seen through these kinds of cases and what the respondents have brought up in their defense. So things to consider.
On the issue of these behested payments, we treat behested payments to all types of nonprofits the same, and there's no guidance that in terms of the general purpose versus a more specific. I'm thinking of like you're behesting for the Girl Scouts or something, some nationally well-known charity that's a 501(c)(3) versus some obscure charity that may have been set up by the candidate's cousin or something. We don't have any, in the statute I'm talking about, there's no differential treatment in those kinds of things. They all have to be dealt with in the same manner.
They're all behested payments under the statute. As to how they're treated by us would be determined by you.
So we could, by regulation or other manner, discriminate to lighten the load, so to speak. If they're behesting for nationally well-known charities, I just don't see that that's something that we should be thrashing. I think it's more getting to the real problem is where they, legislators often will set up a charity that they use sort of to advance whatever it is that they want to advance. Oftentimes it's covering outside the lines. In terms of workload of the commission staff, it just seems sort of fruitless to treat the nationally well-recognized charities in the same manner as the others. Any other thoughts on that?
I agree, and I think that we addressed it in the perceived or real benefit, personal benefit, because we look at it as, is this some sort of personal benefit to the public official? And then we handle those cases differently. And you're hitting the nail on the head as to why I'm proposing for this to be added to Streamline, because we don't want to spend a lot of resources on behested payments, national charities, or whatever the example is, that were filed within 100 days of the due date, or they tried to comply, or they missed their deadline and now they have filed. And these are not the mainline cases that we want to bring to you. So I think we're in agreement as to how we want to spend resources.
I agree. Thank you.
So just so I'm clear on that last exchange, though, I don't hear you endorsing, Ms. West, some rigid differentiation between so-called established charities and everybody else in the world. Instead, what I heard you to say is that under the standard that you've articulated, perceived personal benefit, you think that you and your staff can correctly identify those circumstances where something is a sort of bona fide charitable behested payment, as opposed to something that's clearly set up to benefit the public official, though. Is that right?
Certainly. And in the case that we brought to you a while back, one of the reasons that was a mainline case was because his children got scholarships from that charity. So that's what we're talking about. Whether that charity was nationally recognized or not, it would be the same analysis.
All right, thank you.
Okay, moving on to roadblocks for enforcement. This kind of bleeds over into my legislative ideas, some a little more realistic than others. So I'll caution you right now. But so the roadblocks to enforcement, one of the things that we're toying with the idea is about subpoenaing out of state, because as you know, LLCs, I know Commissioner Hayward has expressed interest in this. They're a difficult group, and so a lot of them aren't necessarily located within California. And so making some sort of inroads into our ability to issue subpoenas in other states and have them enforced, it would be helpful to us. And then LLCs, I would just point out what we can do. So those great interns I talked about in enforcement, what they did for me is they gathered 10 different LLC names. And this group they got from major donors. So they chose 10 LLCs that were major donors. And then they were set with the task of going to Secretary of State, Department of Business Oversight, Real Estate, all the different departments, and see what public information that they could obtain without a subpoena. And it was dismal. And so one of the things that they came back with is that they could find out the entity type, like it's a domestic LLC, which means it's a California LLC versus registered in another state, the jurisdiction, the business address, the agent for service or process, which is sometimes a business, and the purpose. However, this is an interesting thing about the purpose. It can be as general as the purpose of this LLC is to engage in any lawful act for which the LLC may be organized under California law. And as not exactly helpful when you're trying to figure out what the LLC does. And so we have identified this as a problem. And so when you see our legislative proposals, we have some general ideas as to how we can help, because we're really only concerned with LLCs participating in California elections. And if we take it from that point of view, then I think that we can come up with some solutions. So, and then the other parts of this would be for limited peace officer access, we have problems obtaining information, problems with no official badges, and our safety of our special investigators. So I'll give you some examples. When special investigators investigate the laundering cases, they have to go out in the evenings because that's when people are home. And so you're going out into an evening of sometimes not a terrific area, because these are generally the people that are victimized by the laundering scheme, because it's their employer, it's their landlord, it's their big money guy in their jurisdiction. And so these aren't the big money people that you're going out and trying to talk to. And so safety of our investigators is always one of our priorities. So we partner up with district attorney investigators. We always make sure to go out in twos. But our investigators have had the cops called on them because they have a laminated badge. And it's not very convincing. It doesn't look great. And so, you know, we try to coordinate with law enforcement as much as we can, but it doesn't mean that people are going to open their door for a laminated badge. So this is part of the proposals that we're hoping that gets some traction this year. And then advertising rules, make the rules the same for everyone, or at least make some piece of disclosure on every ad. It would help us with resources infinitely.
Can I just put a little check mark against that? So even if there were just the paid for by,
Yes,
like the feds have
yes,
for candidates and parties. Yeah.
yes, please. My mom will be so proud.
On the question of LLCs, do we need statutory authority to be able to require additional information furnished?
Well, I put it on both. I put it on the legislative slide and the regulatory slide because I really just hope that we do anything that we can. And so in talking about the regulations, maybe record keeping, separate record keeping requirements, maybe certain things that we can do once CARS is passed. But for the legislative proposals, what I was about to talk about was increasing the disclosure requirements for the LLCs when they participate in California elections. So instead of on a campaign statement, it just says the name of the LLC, maybe it says the responsible living human, breathing humans that authorize that contribution to be made by that LLC. Something like that, something that actually gives us a foothold into finding the information and being able to say, oh, look at this campaign statement where it has John Smith, John Smith, John Smith as the person that authorized for all those LLCs. Because you have a lot of jurisdictions that have aggregation rules, but no way to really enforce them because getting information on LLCs is so difficult, because then you're finding who directed the contribution. And direction and control is an iffy standard. So we just need something that takes this personal responsibility and gives us more information. And that would be great, because not everybody's a major donor and not everybody is filing other statements.
And where LLC is a subsidiary, if you will, of a corporation, the managing member is often not anybody of authority. So you have to kind of think about what you would require in the way of additional information for it to be meaningful.
I totally agree. And I'm completely open to people that are far more knowledgeable about LLC structures and how we could best get this information. This is me bringing this up as something that I'd really like to look more into and maybe have the thinkers in the legal division kind of like poke around at it and figure out what the best way forward would be. I just kind of throw things at the wall and see if they stick a little. But the other part of the LLC equation is I'm going to give a shout out to Senator Umberg because he has the SB 300, which is about the ballot measures. It extends to candidate campaigns as well for the foreign contributions. And that's something that came up in 2016 as legislation, and it didn't pass. And the commission supported it in 2016. We supported it again this year. And I really hope that we can do whatever we can to push that forward, because as we know, the FEC is having trouble enforcing that right now. And so it would be nice. Yeah, see, I can be nice. And so it would be nice to be able to do these investigations, not into just ballot measure committees about foreign contributions, but also candidate committees, because this is California and we should be able to look at all of them.
Can I just add a little coda to what you just said, which is, I mean, Delaware and also the Delaware, the West, Nevada, corporate law is justly criticized internationally for not having to have a real human being behind some of these fictitious businesses, because that does create an opportunity for other kinds of money laundering, not just the kind that we care about. And I think it would attract quite a bit of attention if we could figure out a rule that we liked that would require a human being to be identified along with the LLC. I don't know if the attention we would be positive, negative, or orthogonal, but I think it's a bigger deal than just what we're talking about today, and it'll be interesting to see how that develops.
Okay, so talking about the peace officer, the limited peace officer consideration. So, and talking to the investigators, they're not really asking to become sworn officers and carry guns. They're really asking to be more like the Department of Insurance Special Investigators, where they have a badge, they have access to criminal databases to get information, to be able to better locate respondents and witnesses, access to the informational databases from other state agencies, and just this level of cooperation by them having this limited peace officer status. And so that is something that we have in as a legislative proposal this year. And we've done the research as to which sections it would need to be and the requirements. And so it's something that I think it would really help them out, because then they would actually have a badge as well. And they'd be able to show that to other they show it to law enforcement and say, see, I'm real, this is metal.
I mean, the lapel pin doesn't do it?
It does not. And so I just think it would really help them and their safety and be able to give them a leg up in investigations and help us track down people, which is important in these investigations. It's difficult when there's a common name in a metropolitan area, and it would be very helpful to be able to have some more information for that.
There's no riot gear, right?
No, that's just for the office. So, and then for out-of-state subpoenas, we've been looking into different proposals and legislation that we can do. And Executive Director Jones brought up the Connecticut law. And so I've asked him if he would mind saying a couple sentences about that.
I don't mind at all. The law that she's referring to is early on in my tenure, we were successful in getting the legislature to expand long-arm jurisdiction to any entity that had a government contract in the past that was later on challenged under the ethics code in Connecticut. It actually ends up being very narrow, because really with attaining personal jurisdiction over somebody, you generally have to prove that they had contacts to the jurisdiction and that, those contacts led to the bad acts. And this just jumped over that with respect to if you had a government contract that was proof that you had contacts, so it just moved the ball forward. That applied to parties, somebody who was a respondent in an investigation. For people who are outside of that class of people, non-party witnesses who you need testimony from, I have a lot of experience in that in 3 different jurisdictions, Virginia, DC, and Connecticut. Mind you, all of the experience in those states was when the adjoining state was less than 20 miles away. So it's a lot easier to, and it happens a lot more often. There is a uniform act that I believe California is a party to. Most of the states are. And the general rules under that act are that first you have to, for an administrative proceeding, you have to go to a court, petition the court for the need for a subpoena. Then that subpoena has to go to the other jurisdiction and be either blessed by their court or, if they have different rules, served under the rules of their jurisdiction. And then the typical rules in the other jurisdiction is that the deposition or the production has to take place in that jurisdiction, which becomes problematic if you have, well, for example, a Delaware corporation, that even if you can get a petition, get it executed in Delaware, you still have to go to Delaware to hold the deposition. And in my limited experience in this realm, not in Delaware, but generally under these, is that you get everything set up in the county where the person's located and then they don't show up. And so you're in the awkward position of having to go back to ground zero to enforce the subpoena. The good news is at the end of that, the local court will generally issue sanctions under the subpoena. You don't have to get those sanctions from the other jurisdiction. But there are opportunities legislatively to sort of make it a faster, easier track for particular types of violations. But that would have to be sort of case by case.
So we're definitely interested in pursuing anything that makes it a more efficient process for us. Thank you. And so another thing that we were thinking about for legislative proposal would be the public agency campaign ads as a bright line rule, as opposed to what you can't do and a weighing test and doing all this. We were hoping that we could work with legal and give them some examples that we had seen, maybe from those advisory letters, and come up with something that would apply to everyone and everybody could very clearly know what the rules are and where the line is. The advertisement rules I mentioned earlier, that something would be great on every ad. And then for lobbying audits, a lot of what you see that when it says Franchise Tax Board audit or FPPC audit is just really, really good work that has uncovered some things for us and given us a starting place. A lot of these cases that we talk about, especially with lobbying, you just need a starting place. And Franchise Tax Board had gone under quite a severe reduction in their political reform division workforce. And so the lobbying audits have suffered because of the lack of staffing. And so under 90001, it calls for a 25% chance of being audited for lobbying firms and lobbyist employers based on a random selection. And then unfortunately, I have the number here, FTB's resources do not allow for the completion of all mandatory lobbying audits. Only around 10% of the selection pool had audits completed by the FTB and 2 of the prior cycles. So we're talking about a pool of, oh man, this is very hard to read. Hold on. Oh, good, I printed it. So they had the resources to complete 20 out of the 20 that were selected, 16 audits for the 2014 lobbyist employers and 19 for the lobbying firms in the 2014. And 14 in the 2016 lobbyist employers pool and 13 of the lobbying firms in 2016. That's the totality of who received the mandatory audits in those years. So my proposal for legislation would be either we find a way to become very vocal and public about fully funding the Franchise Tax Board audit program, or we take on more of those audits ourselves and receive the funding. But either way, audits keep people in compliance, and without the mandatory audits being done, there's always this risk of people no longer taking that as a serious threat. So I really feel strongly about this because Franchise Tax Board and the FPPC auditors all do a great job, and it's really a terrific deterrent. So I would hope that the FPPC can do something about that.
What's your sense if we were to take on more of those types of audits ourselves? How many new staff members are you thinking?
I would think that at some point, the auditors would need to become their own division. I mean, with the contract auditing, they barely do enforcement cases, if at all, anymore. So it's very few and far between. And so I would, hard to tell. I mean, it depends on if we're just talking about the lobbying workload, or we're talking about additional audits, if we're talking about, filling in other gaps. So just with the lobbying workload, I would, at least 2 auditors, maybe 3. But to do a good, thorough job and become a program that has the same level of training as the Franchise Tax Board program does, I mean, we would need positions to do that.
And let's assume that we had additional auditors and we were performing those audits. Is there then an additional sort of a ripple effect then that by virtue of those audits, we would have more enforcement cases, and more enforcement cases would dictate a larger attorney staff and investigator staff and enforcement then? So what sort of, if you play it all out,
Sure.
What are we looking for in terms of resources in your mind?
Right. Well, even just as it stands now, we need more enforcement staff to decrease the time periods that it takes to do a case from start to finish, and to continue to prioritize those cases we talked about earlier. But if we are going to do more audits, then we would need at least 2 more attorney positions, and then the intake position to keep balanced out, because we have to keep the intake moving in order for the rest of the cases to move.
Isn't there a legislative inhibition to us to say that we have to do a bill for
I'm sorry, I didn't catch that.
Okay. Right now, the law statute requires the FTB do those audits. I don't think there's any pathway other than legislation for us to take it over.
It would need to be legislation, yes. And I think that's how we would get the positions as well, to fund that additional duty.
Do you know how many auditors FTB has been using historically when they were keeping up?
They did a presentation last year, I think it was, they used to have 40, I think was their staff, and now they have maybe 11. I don't remember the numbers off the top of my head. I'm guessing completely. They were here yesterday. We should ask this. But yeah, they've been reduced drastically. I mean, if you think about it, it makes sense, because with Franchise Tax Board, they're not a revenue generating portion of FTB. So when you're looking to cut, I can see if you're looking at it from an administrative viewpoint. Not that I agree with it, I'm just somehow making rationale for them. Anyway.
While we're in this area, I wanted to raise a question about, what do we call it, state procurement process lobbying.
What did you say?
Is that outside the PRA, or is that just something that's developed without our knowledge?
It is outside the PRA. What was, legislation was introduced several years ago, maybe 5, I think, to include procurement lobbying and procurement in general under the act. And it was determined at that point, the FPPC took the position that we're not the most educated agency on that area, and there were other agencies that had more knowledge into the procurement and contracting process that would be more appropriate for that enforcement and regulation. So I think that was the position that was taken at the time, and it hasn't been brought up since.
Okay. And does franchise tax board, audits verify that persons claimed on their gift receipts, entertainment receipts?
Do franchise tax board notify, I didn't catch.
No, in their audits, do they require substantiation of the person's claim to have been entertained?
They follow the auditing guidelines. I'm serious, I get most of your question. See if this answers it. I
have a receipt for a restaurant in my records as a lobbyist, and it says that I entertained 4 people. Do they verify that all 4 people were there on a spot basis at least, or is this taken as?
Okay, I understand what you're saying. So I don't know the level of detail that they dig down to. I know that they would get the receipt and validate the receipt and make sure that it matches the expenditure, but they're not going to do an investigation in that. So what would then happen, unless there's some red flag, so then what then happen is as an audit report, it would be noted, and then when brought to our attention, then we would look at the audit report and decide, hey, maybe we want to look at this a little more and maybe do interviews or whatever. And that would be the same if it was our auditors as well, because it would be just the same auditing principles that they would be following as to when they pursue looking into something more. So that would be the same.
Okay.
Okay. Okay, regulatory proposals. These are short. It's just, like I said, LLCs, throw it at the wall, see what sticks. Really brainstorm what we can do, how we can be more proactive, what suggestions we can make. Perhaps when you're at Kogel, you can gather some information, see if there's any LLC trainings, what other jurisdictions are doing. Enforcement procedures, there's some little fixes we want, but we also would like to open the discussion about electronic service process, really save the agency a lot of money on personal service. I'm sure you know that there's a lot of people that don't pick up their mail if it's a return receipt. So it causes us all sorts of problems. And then just little cleanups for us, fixing the administrative termination regs so we don't actually have to notify relatives of people who have deceased. And we could look at bank records if we have bank records and not necessarily just use the amount from a campaign statement. So those are just little fixes that we're going to propose. And then the big one is the bottom one, which is we're hoping that the commission is looking to do some sort of presumption about cash because it seemed to be a hot topic this year. And maybe when there's cash, plus there's no record keeping, that maybe we have some sort of presumption of something, presumption of personal use, presumption of laundering, presumption of something. Obviously, we would need to work out what other criteria would need to be present, but we would like a starting place for these cases since they're very difficult to prove cash cases. And so we would like some sort of deterrent to this sort of behavior. So we're really looking hard at this to see if there's ways that we can make this work to help deter people from using great amount of cash without any record keeping to where you really have no idea what happened with that money.
If I may, when you say cash, Ms. Webb, you all right? No. See, when you say cash, nothing happens, but when somebody else does. Do you mean like official Federal Reserve legal tender, physical?
I do, because what has been happening in the cases this year is when people are withdrawing large amounts of cash from their campaign account, then there's no record of where it went or how it was spent. So one of the things the commission had brought up to enforcement this year was, hey, why aren't we throwing the book at these as personal use? And it's like, well, that's really difficult because we're having to be able to say that we can prove that that was not used for a political, legislative, or governmental purpose. And if the person says, no, I went and, paid for flyers, I don't remember the guy's name, and, he was the guy that delivered them, so it was just these, random people that I ran into in the street that they decided they only would want cash, then, these cases are very difficult to prove. So we're looking for some sort of inroad into affirmatively saying, hey, if it's cash plus no record keeping, this causes a doubt against you.
Right, this shifts the burden of proof to the person who withdrew the cash in this example.
Right, and of course, with all presumptions, it's a rebuttable presumption, so we're not saying it's 100% you're convicted. It's just something that gets us a little farther along in the process.
Yeah, but unless you produce receipts, it's yours.
Right, and I've seen a lot of handwritten receipts, so.
Well, I know the IRS takes that position on deposits into your accounts. If you can't prove what they were for, they're considered income. So I guess they can do it, we can do it.
I'll look into that.
So I have a question. Your regulatory proposal on the cash expenditures is to create a presumption, presumably because, in your judgment, which I agree with, the cash expenditures raise all sorts of potential public harm. Another option, it seems to me, is that we change the commission's policy with respect to the sort of the starting point of penalties for those types of violations. In your judgment, would you, if we did that, as opposed to creating some type of presumption, do we get essentially to the same place in your mind? I mean, a high fine, more cases, deterrent effect. Just curious.
That's interesting. I guess it depends on how much you value us being able to say you misused those funds. So, and sometimes there's value in that. There's value in saying, no, this was not right. This was cash that you took out and you can't show what you did with it. And we can say that in the story, but it's really just depends on how much value you also be able to put into, and we're charging you with misusing those funds. So it's just kind of, I'm kind of okay either way. I think that sometimes when you put a crack in like this, where you say the presumption has shifted a little, then it causes you to find more. So you have that in your favor as well, is that then you have a little more leg to stand on to have these investigations and issue the subpoenas and find all the information. But yeah, I think that depends how you weigh it. Okay, and so the year to come, I don't know if anybody noticed, but March 3rd, the 90-day period for 24-hour reporting starts in a week and a half. A week and a half. So that's, I mean, a week and a half. So obviously that's going to keep us busy. Having the early March primary is going to cause us to do a lot more stuff in between the elections. So I would anticipate our pre-election efforts restarting very soon, AdWatch relaunching with the changes that I had discussed, and yeah, busy year. So we're looking forward to it, and I'm looking forward to it, and so we'll continue to do what we do. And I just wanted to give a shout out to Dominika Wajinska because she was the one that really helped me put this together. And she's our AGPA. She's right there in the scarf. And so, you know, without her, you would have gotten just me writing on paper. So, so I mean, really, it's a benefit to everyone. So that's the end.
Well, thank you. Thank you very much. I think this has been, it's been very helpful, certainly very thorough. And I want to acknowledge that I guess the impetus for this, or the idea behind this, did come out of our enforcement task force. They had suggested that we do something along these lines. I think it's a good idea, and I would hope my colleagues would agree that if we do this once a year, maybe even every 6 months, there might be some benefit to that.
I think you just made her cry.
Sorry, Dominique. Really, sorry, not sorry. But honestly, great job, Ms. West. It's been very helpful. So thank you very much. Do other commissioners have comments?
Yeah, I just, you know, we don't get a chance to sort of take a step back and look at enforcement outside of a particular case. And I think a lot of people in the public don't realize just how insulated the commissioners are from what happens in enforcement for various due process reasons. And okay, that's all to the good. So yeah, if this is done regularly and is kept up, I think it's a huge step forward in terms of just, you know, good governance of the commission. And, you know, it's really, really informative. I mean, a lot of the facts you presented today, I certainly didn't know. You know, I think there are things that are sort of in the air and enforcement we're just not exposed to. And so I think, yeah, it's super helpful.
I'll save any balance of comments for later, but for now, extremely informative, very well done. Thank you very much. And I'll save my commendations for your amazing staff for a little bit later. We're going to have some comments, I take it.
Once the commissioners are done with their closing comments at this point, well, we're going to invite public comment, and then if you want to make some final comments at the end of public comment, that's fine too. So, Commissioner Hatch, before we open it up to public comment, did you have anything you wanted to add at this point?
No, I love the presentation. I did offer some thoughts in context. I pretty much covered what I wanted to bring to the attention of the group.
Okay. So we will go ahead and open it up to public comment. But before we go to live public comment, I just want to highlight that somebody named Aaron Peth has written in saying that it was an extremely helpful and detailed presentation. Thanks so much for scheduling it. So thank you, Ms. Peth, wherever and whoever you are. At this point, we'll open up to a live public comment.
Former executive director.
Thank you, Commissioner Hatch. And welcome, Mr. Kaufman, to the microphone.
I'll try that again. Good morning, Chair Matich, commissioners, and staff. This is your live comment from a live human being. Stephen Kaufman, Kaufman Legal Group. I am here speaking on behalf of myself, my firm, and as the former chair of the FPPC's Enforcement Review Task Force. I want to commend you for engaging in this lively session this morning. It is something that we on the task force had suggested you do, and appreciate that you embrace that and have gone forward with this process, and hope that you'll continue to do it, maybe not in the quite lengthy way that it was done today with all the background, although I think it was great that it was done today as an initial step. But I hope you will do a periodic review, either semi-annually or annually, to continue this conversation, because I think it helps to understand the issues that are pressing, the issues that are bogging down your staff or taking your staff's attention. And I think it's important for the staff and the regulated community to hear what the priorities are of the commissioners in pursuing these laws. So thank you for that, and thank you, Galina, for the thorough presentation and for the humorous asides. It helped us get through this today. I just have a couple of other comments in response to that. And first of all, I just like to say, look forward to working with staff and the commission as you take up some of the recommendations that were made today with respect to both regulatory changes and legislative changes. I had just a couple comments on the regulatory side, in particular the streamline regulations, which Galena knows are near and dear to my heart. Having gone through this process last year, I thoroughly embrace looking again at some of the limitations that were included in the regulations as relate to 24-hour reporting. And as you just saw on the monitor here, 24-hour reporting does start on December 4th. There will be a few holidays and a few vacations probably planned during that period of time between December 4th and March 3rd. And you can only imagine the kind of havoc that wreaks on 24-hour reporting. So I think you need to have an understanding and appreciation for that process. And even though I know the regulations don't really speak to, or the regulation doesn't really speak to time constraints this far out, there are very strong realities with 24-hour reports that I think need to be considered, and hope that some of the time restrictions that are in the current regs will be revisited. I would also add that I think revisiting the thresholds is probably a good idea for the reasons that Galena outlined during her presentation, and agree that including major donors or more specific provisions relating to major donors and major donor notices would be an appropriate inclusion in the both the warning letter provisions and streamlined provisions, and that behested payments. Surely there's a place for behested payment reports in that regulation. I would add, though, that I would hope that you will prioritize looking at those regulations and do take them up in 2020. I know things are tight between now and March, but there's going to be a prevalence of these type of issues that come up for obvious reasons in this election cycle. And it would be great to have those issues resolved, certainly by the time we hit the November election cycle. So I urge you to do that. I have one other comment, one other addition perhaps to the legislative suggestions. It's an issue we discussed a little bit as part of the task force, and it's been discussed off and on over the years, and that is the issue of private right of actions and tightening up the statutory provisions relating to private right of actions so that issues where the FPPC determines that there is no violation of the act and there is no issue will preclude folks from kind of running the FPPC and going into court to try and pursue those type of cases in civil actions. I think there's a big distinction between cases, and you may or may not appreciate this, but the private right of actions provide a 120-day provision for people to request that the FPPC pursue a civil action. And if the FPPC fails to do so, folks can go into court and pursue those cases on their own. I think there maybe were times in history, and the intention of the law was where the FPPC, failed to act, folks could go into court. And I think there's a big distinction between failing to act and choosing not to act because it's not a valid claim. And unfortunately, the act doesn't really distinguish those situations, so that in the case where there isn't really a valid claim under the act, folks can go into court and tie up a potential respondent in a legal action that they shouldn't be a part of. And we unfortunately have had to represent clients in those circumstances over the years. It leaves you in a fairly helpless situation where you have no place to go to get help to defend those cases. And I think there are things that can be done with the act tightened up in that regard that would preclude those situations in the future. And would like to explore those issues with the FPPC when you're considering your legislative changes.
That sounds really interesting.
Yeah, can we?
Question, Mr. Coffey?
Go ahead, Commissioner.
Sure.
Thank you. How big is the universe of private actions where the FPPC's PRA is involved. Can you give me a sense of scope?
It's not very prevalent. It's unique, but it has been used and abused over the years. There have been a couple of situations where there have been mass private actions brought against, for example, a decade or so ago, against major donors from all over the country who had failed to file campaign reports. There were requests made on the FPPC to pursue civil cases, and the FPPC, in one case I know, didn't respond at all. And there were dozens, if not hundreds, of major donors that were sued in civil court and had to deal with that issue. I think there was another mass case involving other donors that I can't put my finger on right now. And then we've had a few in the San Diego area in the last few years that have arisen by a habitual litigant who has gone into court a number of times to pursue cases down there after filing civil action requests with the FPPC. So they're not usual, but they do happen. And I think the intent of the provision when it was drafted was one thing. I think it was meant to kind of protect the public from an agency that may not act on behalf of the public and provide the public with another avenue to enforce the laws. But instead, it's kind of become a weapon for people who are pursuing frivolous actions in Superior Court.
So,
Thank you.
So I have a question. So suppose that the commission receives a complaint and the commission decides, the enforcement division decides and determines that the violation alleged is not one of the priorities for an election year, let's say, and that the evidence, at least the evidence that was presented to enforcement, wasn't sufficient to open a case. That's not the same thing as saying there was no violation, there's definitely not anything bad here. Is it your position that that type of a letter, though, should preclude civil action?
Well, I would like to see a circumstance where so that is an issue that's distinct from determining that there's no violation, right? So a letter could say there's no violation of the act.
Right, and that's what I'm trying to find.
There can be a determination that there is no violation of the act. There are other issues where the FPPC would look at it and say, that's not a priority of ours. We're not going to enforce something like that. It's a minor little technical thing, and we're not going to pursue anything along those lines. I don't think that those should end up being the subject of civil actions, but I don't think that there's anything, and I would like to see that encompassed by what we're talking about, but those are two distinct issues. And I think it's unfortunate when a circumstance like that does lead to civil action because it's often very difficult to explain to a court. Yeah, this might be a violation, but it's not something the FPPC would pursue. But usually courts look to the leadership of the FPPC on these issues when making these determinations. And so some process by which those type of actions can be precluded by an act of the FPPC, even if the act is to not pursue it, I think would be a positive way of preventing these frivolous cases.
So the answer is yes. You think if we, without saying there has not been a violation, say we're not going to pursue it, you're advocating not allowing subsequent civil action?
Yes.
Okay. All right. Fair enough. Fair enough.
In terms of venue, is this something we can do regulatory, or is this a statutory issue?
I think it's got to be done statutorily because it's it's part of the enforcement statutes in the PRA.
Okay, thank you.
Okay. Thank you.
Thank you very much.
Chair Maddox, Commissioners. My name is Nick Sanders. I'm with Sutton Law Firm. I'm here on behalf of my firm and the California Political Attorneys Association. I have brief comments. Just want to say that CPA, we're very pleased with today's periodic review. Thank you, Ms. West and staff for putting it together. We think it's very informative for the regulated community, for us to hear the commissioner's priorities, and for us to learn more about the internal processes. So these are great. As often as you can do them, I think that we'll be very actively watching. We also just want to reiterate our desire to work collaboratively with the FPPC where you guys deem that it's appropriate and necessary and useful to what you guys are trying to accomplish. So to that end, we have an enforcement subcommittee within CPA, and if you'd like, we are going to be meeting again soon. We can submit our comments in writing to what we've seen today. We'll reach out to you and discuss that again soon. That's it. Just thank you very much. Great job.
Thank you. Any additional public comment, live public comment? All right. Any additional commissioner comment at this point? I see Commissioner Cardenas has comments.
I'll try to be brief. I don't possess what's necessary to I think really do justice to the issue, but your staff is, as you know, just a bunch of heroes in our estimation. 46 years ago on this day, a great American was taken from us in Dallas, Texas. And while he was with us, he gave us some profound insights to what it means to be an American and what it means to live in a democracy. I don't remember the context of the speech, but one of them was something along the lines of democracy is never a final achievement. It is a call to untiring effort. It is a call to untiring effort. And what I see and have heard and sense about your staff is that they are untiring in their efforts to uphold this sacred thing that has been created in this country for the world to see and emulate if it can. It's an honor to be associated with your staff. Thank you.
Commissioner Hayward? I know, that's a tough act to follow.
No, I can't follow that.
Commissioner Hatch, would you like to follow that?
Not so eloquently, but I do know that often the work that's put out by the staff of the FPPC makes us sometimes think that there are a lot more of them than there really are. It kind of, as a former Marine, makes me feel that they're the few and the proud. They do a good job. They're dedicated. They often call me back at 8, 9 o'clock at night, which tells me that it's above and beyond. And thank you all. This was a wonderful presentation. It helped a lot of things in perspective.
Thank you.
Well, I guess I've only been here about 6 months, so I'm the most junior member of the commission at this point. But even in my short time, the enforcement staff is world class under Galena's leadership. I mean, all of you guys are just lights out. Great job. I look forward to continue working with all of you. And thank you to the folks from the regulated community that came and gave public comment today. So I see this as the beginning of a process to continue to refining our enforcement processes and become more efficient and increase transparency. So with that, thank you all very much for being here, and see you next month. But
And I would just like to say, I feel the same way. They're really terrific, and to do this every time, I mean, it's hard because you guys see at the commission meetings, complain against about enforcement, respondents complain about enforcement, and sometimes it can get you down, it can feel a little thankless, and having you all say what you say and give them these accolades right now, it is immeasurably priceless, and I really appreciate it because they really deserve it. They're terrific people that are dedicated. It's the only reason you would stay in enforcement as if you're dedicated. So it's really a great staff, and I'm just pleased as punch to have them.
On that, thank you all very much.